What's going on, Crew? How are you today?
I'm happy that it's Friday.
Yeah?
I got a lot of plans for this weekend. I think it's going to be the first time I break out my canoe.
No way, really?
Yeah, go for
Where are
a
you
ride.
going canoeing?
Probably by on the Passaic River, Lincoln Park. Going by Willowbrook Mall to Little Falls.
Nice. With your kids?
Yeah, my son. It's a two-seater canoe, so my older son likes to come with
There's
me.
no alligators or anything in the river, right?
Well, if they are, they won't live for long. So they'll probably be sick already. So I think we can handle it.
Good. Well, this is awesome doing this with you. Let's go over some questions that I think clients might really like to know about.
Sure.
Especially as it relates to civil litigation. Let me ask you first, what are the first steps a business should take if a business is facing litigation here in New Jersey?
Well, typically a business would learn that it's facing litigation when it's served with a complaint. So the first thing it should do when it's served with a complaint is to call me, or talk to an attorney and to find out what its rights are, when its deadline to respond to the complaint will be, and what its potential defenses will be. Mm-hmm. If you ignore a complaint, then it becomes more expensive to defend. Usually, the deadline to respond to a complaint starts to run from the date that you're hand-delivered or personally served with the papers. Mm-hmm. So once you're served in New Jersey, it's 35 days. If it's in state court, if it's in federal court, it could be 20 days. It could be 30 days, depending on when you're served with the complaint. But the idea is that if you don't answer within the time set by the court rules, then a default can be entered and potentially a default judgment. Mm-hmm. And then it becomes more expensive to defend. You would have to vacate the default if you want to defend it on the merits. Usually you're not served with the complaint out of the blue. Usually before you have a complaint sent to you, you know that you're in a dispute with another party, and they might have made a demand letter with you. Maybe you had an agreement with them. I guess it would depend on the nature of the dispute and relationship with the parties as to the amount of notice that you received before the complaint is filed. But once the complaint is filed and you're served, then things are real. And the court is involved, and it becomes much more time sensitive. So the first thing to do is to talk to an attorney.
Okay. And how long does a general commercial litigation matter typically take to resolve here in New Jersey? And what are some of the factors that can affect that timeline?
Well, commercial litigation comes in all shapes and sizes. Sometimes it's a business dispute between two partners or two members of an LLC or shareholders in a company, and it could literally take years to resolve. Another type of commercial dispute is a book account where you delivered some goods or services and you didn't get paid. Now, that's something that is much more streamlined, less complicated, and usually would take less time to resolve. So it's really case-by-case, fact-sensitive analysis.
So what are some of the potential risks or consequences for a business that's being sued here in New Jersey?
One of the risks when you're being sued is to have a judgment entered against you. That's typically what a plaintiff is looking for. They want a judgment declaring that the defendant owes them money. But sometimes a company could sue for something other than money, like non-monetary relief. Sometimes you could sue for an injunction or some other type of equitable relief. For example, if a company is competing with another company, let's say that there's a copyright or trademark or other intellectual property rights at issue, the relief that the plaintiff could seek would be an injunction to force the defendant to stop doing something, to stop selling the allegedly infringing item. Mm-hmm. So one of the risks that defendant faces in litigation would be an adverse judgment against them. And the last thing that they would want is to have that judgment entered against them by default without having an opportunity to raise their defenses. The best thing to do when you are facing litigation or you've been served with a complaint is to consult with an attorney to find out whether or not the complaint states a cause of action, whether it alleges claims that you need to respond to or to defend against, and possibly also whether you have a counterclaim or affirmative claims that you could raise against the plaintiff.
Yeah, that was going to be part of my next question, which is what are the possible outcomes? So you're talking about money damages and injunctive relief are probably the two big ones and different ones, right? So money damages, people can understand that pretty well. Someone claims that they've been damaged for a certain amount. The plaintiff in that case, if they prevail, they're going to be entitled to a certain monetary amount. The flip side of that is injunctive relief or equitable relief, which is something else. Maybe the plaintiff or the party suing is seeking to compel the other side to do something or to stop them from doing something. Is that right?
Yeah, that would be a typical an injunction to stop somebody from doing something. It's a little bit more rare when you're asking the court to compel somebody to do something, but that happens too. I mean, one example could be specific performance, where you have entered into a contract that obligates you to do something, to perform something, whether it is to turn over certain items or a lot of times specific performance comes up in transactions for the sale of real estate. So real estate is, in New Jersey at least, considered unique. So if you're a buyer and you have a contract to buy real estate or a house or some other property, real property, and the seller gets cold feet or otherwise breaches the contract and refuses to sell you the property, the buyer could be the plaintiff and sues for specific performance, asking for an order from the court compelling the seller to transfer title and to sign a deed and to make the plaintiff the new owner of the property. And if the defendant refuses to comply, then the court can enter a judgment or an order that transfers the title to the property, even without the seller's cooperation or consent.
Mm-hmm. Yeah, and New Jersey's unique because it has a law division and a chancery division, right? Where the chancery division is the division that deals with these non-monetary claims, whereas the law division is solely monetary. Am I describing that correctly, or is that...
Well, that's the way it had been in New Jersey for many, many years. More recently, maybe like 20 years ago or so, there had been some reforms or changes. So now you could sue in the law division and get an injunction. And likewise, you could also sue in the chancery division. You could also get money damages. But typically, in order for a lawsuit or a claim to be filed in the chancery division, you have to be looking for non-monetary relief, whether it's an injunction or rescission of a contract, if you want to cancel the contract based on fraud, or if you're looking to compel somebody to do something. That's something that would typically be filed in the Chancery Division. Traditionally, that's when you're looking for non-monetary relief. A lot of times it comes up in election matters. If you're alleging that there was some fraud or impropriety or lack of compliance with the law, with the procedures for an election, then you would want to have an injunction to either have a recount or a revote or some other type of remedy that has nothing to do with granting a money judgment. But still, the Chancery Division has the right to enter money judgments also, along with other non-monetary relief. And likewise, the Law Division can also grant specific performance or just about any other remedy that's available in the Chancery Division. So that makes it more of a strategic question for the plaintiff of where to file and when. A lot of times a plaintiff would like to file in the Chancery Division because you get the court's attention a little bit sooner, and it is more likely for you to get the relief that you're looking for in a shorter period of time.
Well, that was going to be my other point. Is it seems like you really need to have an attorney who can make that strategic decision for you, or at least help you determine what's best. Do you file in the Law Division? Do you file in Chancery? What are you seeking? So it seems like having an attorney who's experienced in this is extremely important.
Yeah, a lot of attorneys are not so familiar with the Chancery Division, only because it's kind of treated like a different part of the court. And for the last 20 years or so, the relief that was only exclusively available in the Chancery Division is now available in the Law Division. And so more attorneys would file in the Law Division just out of levels of comfort and familiarity, whereas someone who is more familiar with the Chancery Division and the benefits of filing in that part of the court might be able to provide a different or a better service to their clients.
So are there general strategies that a business can employ to minimize their exposure to litigation? I know this is a very broad question, but generally speaking, are there things that businesses can do to limit potential liability?
Sure. I mean, thinking in advance. Proper planning prevents poor performance. So if you think in advance and meet with an attorney to talk about compliance issues, whether it's coming up with an employee handbook or certain policies that you can have or disclose to your employees that can help avoid litigation or disputes in the future. Also, following corporate formalities. If you have resolutions and keep meeting minutes and otherwise observe formalities, that can help to avoid confusion, make sure everybody is on the same page, and that the actions that are taken on behalf of the corporation or the LLC are properly authorized. And just meeting with an attorney to discuss what you're hoping to do, what you want to do, and even sometimes an attorney can raise issues that you would never thought to have raised. You didn't realize were at issue. So sometimes you don't know what you don't know. And making a point of meeting with an attorney to talk about compliance and kind of proactive preventative measures can avoid a lot of expensive litigation in the future.
Yeah, one of the other, I think, really important points is if your business is entering into some sort of transaction with another business or individuals, to have it in writing, have a contract in writing. It always surprised me how often I still see, either contracts that are oral or simply done by downloading some form from the internet and, ends up disputed in a court and there's millions of dollars in question. So what do you have to say to businesses who are in this position and, maybe it's going to be time consuming for them to do this. Maybe it's going to involve a little bit of money to hire an attorney to draft a contract. What do you say to businesses like that?
Well, it kind of reminds me of the movie Jerry Maguire, where one of the clients of Tom Cruise was telling him, "Oh, my word is oak. You shake my hand and then we have a deal. We don't need it in writing." And kind of put some pressure on the agent, the sports agent. He agreed to proceed without a written contract, and he got burned. So a lot of times having a contract is much better, and it's beneficial because it's more enforceable. It's easier to enforce a written agreement than a promise, a verbal agreement. Now, in New Jersey and New York, verbal contracts are enforceable, but you have to prove it. And if there's nothing in writing, that means credibility is an issue, and testimony. And you're not going to be able to get a court to grant relief without having a trial and testimony and allowing the trier of fact to watch the testimony, observe body mannerisms, and make other types of credibility assessments that are expensive. You have to have a hearing, you have to finish discovery. It makes the process longer to get to the finish line. Whereas if you have a written contract in New York and there's a breach of it, instead of filing a complaint, you could file a notice of motion for summary judgment in lieu of a complaint and then ask for the ultimate relief at the very beginning of the case. So one of the benefits of having a written contract is that it's easier to enforce. Another benefit for having a written contract is that sometimes you don't realize that there is a dispute, that there's not a meeting of the minds until you lay out all of the details in writing. Writing out what you believe is the scope and the terms of an agreement sometimes reveals that there is a dispute or that there were issues that were assumed to be agreed upon but were not. So writing it out, hashing out, going through the process of preparing a writing that memorializes the terms of the agreement helps the parties iron out some of the undisclosed or undiscovered disputes that were kind of embedded in the agreement, the verbal agreement. Also, one of the benefits of having a written agreement is that some contracts are subject to the statute of frauds, meaning that it's not enforceable if it's not in writing. Like, for example, in New Jersey, a contract for the sale of real estate would not be enforceable unless it's in writing. For the same reasons, it's easier to prove, it helps to establish that there is an agreement, but then the third benefit is that there is an actual statute that says that a verbal agreement is not enforceable in that context.
Yeah, I think that's the big major difference between oral agreements and contracts, in that, a lot of times I've had experiences where clients will come in and they'll say, yeah, but we had an oral agreement, and they can't say otherwise. I'm right, they're wrong. But when litigation starts, and we can get into this a little bit more, like you said, it's a credibility issue that can be quickly resolved by the court. It needs to go usually through the entire litigation process. So you're talking about the pleadings, discovery. Most likely, you might not be able to get out on summary judgment if it's truly a he said, she said, because there's a genuine issue in dispute. Unlike where you have a written contract where courts, and maybe you could talk about this a little bit more, how courts treat written contracts. They'll look at the actual language of the contract. That is what is binding on the parties, and the court will interpret that. And it's basically plain meaning. And only if there's an ambiguity there will it look beyond the actual four corners of the contract and try to see, well, what do the parties really mean, and consider extrinsic evidence. So when you have a contract and the other side, for example, breached that contract, and if it's very clear in the contract, you're going to have a much, much stronger case in court than you would, and possibly you might be able to resolve it much quicker than if it was just an oral contract and now it's a he said, she said. What do you have to say about that?
Yeah, so a lot of times contracts will have what's called a merger clause. So it's a provision in the contract that says that any other representations or agreements that are not incorporated in the actual written document are invalid and unenforceable. So the benefit of the merger clause is to make sure that it's simpler and easier to prove what was within the scope of the agreement. And there are occasions when the merger clause will not enforce and will not be valid. And that's particularly if there is an ambiguity, like you had mentioned about the contract. If there's something that's unclear, typically the definition of ambiguity is if reasonable people could interpret it in a different way. So if there is a provision in the agreement that could be interpreted in multiple ways, then extrinsic evidence could be admissible. The court may consider emails, correspondence, or testimony, and that would expand the scope of the litigation, make discovery more relevant, and just make it harder to get to the finish line.
Well, it seems that's why it's particularly important to have an attorney carefully look at your contract and be experienced enough to know how to draft very clear contractual provisions.
Yeah, it would be the goal and purpose of the attorney to make a contract that is enforceable and that doesn't have any ambiguities so that it would achieve the purpose that the parties had agreed to. I mean, it's not always possible. Sometimes a contract becomes ambiguous because of future events that happen that were not anything that could have been avoided or addressed by the attorney that's drafting the agreement. But most of the time, if the attorney is familiar with the facts and has experience in drafting contracts, he can avoid making otherwise simple enforcement process a long, drawn-out litigation.
Now, let's say there's two businesses already in litigation. How does each side build the evidence in support of either their defense or their claim?
Well, typically you first file a complaint and then the defendant would file an answer, and then the process of discovery begins. Usually discovery would consist of first paper discovery, demands, written demands, interrogatories, which would be a list of questions, and then a notice to produce documents where you would identify different categories of documents, like any agreements between the parties, or any correspondence between the parties, or correspondence with third parties that were not a part of the contract that relate to the contract. So just different categories of documents or information that you're asking the other side to give to you. After paper discovery is concluded, then you take depositions, where you would meet with the other side, ask them questions, and learn more about the case. You typically learn more about your case from taking a deposition than even the first initial client meeting. You know, when you get to see the other side's version, you not only assess what facts the other side has, but also how well they'll testify, what type of witness they'll be, and then what you're up against. And then at that point, you could determine whether or not to serve further discovery, or if a motion, a dispositive motion, would be in order. Usually, if you're the plaintiff or the defendant, you're looking to find a way to get to the end of the case without a trial. Usually, the cases that are tried means that something went wrong in the process. In particular, with commercial litigation, like less than 1% of the cases actually get to trial. And the only time that it does happen is either somebody's operating off of a misunderstanding, or maybe somebody's acting in bad faith. But typically the cost of litigation motivates people in a business dispute to make a business decision and to come up with some remedy other than just handing off the dispute to a trier of fact to make a verdict.
Now, let's say there's a business that's being sued. They think that the claims against them are frivolous. What sort of defenses might they have, or counterclaims? Can you bring a counterclaim in court?
Well, any defendant that is served with a complaint has a right to file an answer and also a counterclaim. Now, in New Jersey, you cannot bring a counterclaim for frivolous litigation. There's actually case law on this that says that a counterclaim alleging frivolous litigation is itself frivolous. So instead, if you're served with a complaint and you think that there's no basis in fact or in law, or that the purpose of the plaintiff in bringing the lawsuit was to harass you or for some other improper purpose, there is a remedy. New Jersey, there's a rule in the statute. The rule is 148. What it would require is to send, well, for the aggrieved party here, the defendant, to send the plaintiff a safe harbor letter, alleging that the complaint is frivolous, explaining why you think it's frivolous, demanding that the plaintiff withdraw it voluntarily, and threatening to bring an application for sanctions at the appropriate time after the defendant wins on the merits.
So even if a claim is frivolous, the defendant still needs to engage in the court process and raise these claims of frivolousness, and then might later be able to recover through either sanctions or recovery of the attorney fees. Is that right?
Yes. The purpose of the 148 letter is to threaten the other side and to tell them that it's frivolous and to demand that they withdraw it voluntarily. And they have 28 days to do that. If they withdraw the complaint or the frivolous paper within that safe harbor period, then no harm, no foul. Nobody has claims against each other and the dispute is resolved. If the plaintiff refuses to withdraw it because they disagree with the assessment, or even if they agree with it, they want to continue the campaign of harassment, then they do so at their peril. And the defendant would then have to respond to the complaint, either filing an answer or a motion to dismiss or some other responsive pleading. And then after the defendant wins on the merits, then he could file this separate application. Usually in New Jersey, it would be a motion for fees. And then in that motion for fees, you would cite to the fact that you had warned the plaintiff and you had served the safe harbor letter, and that you ultimately won the case for the same reasons that were set forth in that safe harbor letter. So in other words, if you received a complaint and the complaint alleged that you were negligent, and you disputed that you were negligent, let's say because you were not the owner of the property, and so that there was no basis for the plaintiff to sue you. But then the plaintiff refused to withdraw the complaint, and then you had to file an answer. But then you won for another reason. You were the owner of the property, but you were not negligent. The plaintiff was riding a skateboard and did so and fell, and so you were ultimately determined not liable because you were not negligent. But that's different from the reasons that were set forth in your letter. The only time that you're going to be entitled to collect fees for sanctions for frivolous litigation is if your safe harbor letter articulated the same reasons that you ultimately won.
Okay. What are some of the potential costs associated with defending a commercial litigation matter?
Typically, we would charge an hourly rate to defend a case. Now, there are certain cases where we would offer a different fee arrangement. There's more options available when you represent the plaintiff. When you represent the plaintiff, then you're usually the party that's suing for money, and you're looking to make some type of recovery. And the rules in New Jersey would permit, under certain circumstances, for certain causes of action, for the plaintiff's attorney not to charge an hourly rate, and instead to charge a contingency fee, where you only get paid if you obtain a recovery from the plaintiff, and it's usually a percentage of the net recovery, and typically a third, but it may be different in different types of cases, a little bit more, a little bit less, but typically a third. Sometimes a plaintiff or a defendant can charge a flat fee for defending a case or prosecuting a case, but in commercial litigation, that's a little hard to come up with an appropriate flat fee, because you don't know how much time the attorney is going to have to devote to the case in order to bring it to a conclusion. So usually it's an hourly fee, and the attorney's fees are one of the costs associated with bringing or defending a case.
Another one would be expert fees, right? Depending on the type of situation. I mean, you might need to retain an expert. That expert will probably also charge by the hour, right?
Yeah, it could be expert fees. There's also filing fees or other costs. The court typically would charge a fee for filing a complaint or filing a motion or filing an answer. Different documents have different costs. Another large cost could be deposition costs, where part of the discovery process in many civil litigations is depositions, where you'd have a court reporter, sometimes an interpreter, and they all have various fees and costs, sometimes flat fees, sometimes hourly fees, sometimes by the page, depending on how long the actual transcript would be. Besides having expert costs, sometimes there are also costs for delivering papers or for...
like service of the complaint, right?
Yeah, service of the complaint.
Especially if the party that you're serving is overseas and maybe they don't have a presence here in the United States. You need to go through one of these complicated treaties like the Hague Convention or the Intra-American Convention, I think it's called, where that can be thousands of dollars.
Right, yes. Sometimes the cost associated with bringing a litigation could be prohibitive. And sometimes it's recoverable, but typically in New Jersey, they go by what's called the American rule, where everybody pays their own costs and fees, win, lose, or draw, unless there's an exception. Now, sometimes there's an exception based on a provision in a contract. Sometimes there's an exception based on a court rule or a statute. But those are the exceptions to the rule, and typically everybody pays their own costs and fees. Another large expense that, especially for personal injury cases, could be for medical records, especially depending on the type of injury that's involved and the amount of medical records involved. That could be thousands of dollars in itself. And that's usually something in a personal injury case that the plaintiff's attorney pays for. And so that's part of the vetting process, is that you're not going to take a case unless you're sure you're going to win and get back your investment.
Well, one of the things that we didn't talk about is arbitration, which is similar to litigation, except that arbitration takes place in a private kind of setting, commonly through the American Arbitration Association. There's also, I think, JAMS. There's different types of organizations that are private dispute kind of resolution forums. And in arbitration, the parties also have to pay the arbitrator, right? Whereas in state court, you're not paying for the judge's time.
Right. Yeah, the judge is compensated through your tax dollars, so that he gets paid directly either from the federal or the state government, whereas an arbitrator is paid by the parties, and you have to pay that out of pocket. And that's an upfront cost that could make arbitration more expensive. But actually, one of the rationale and the reasons why arbitration is popular is because it's less expensive than litigation. It's usually less expensive than litigation because it's more informal. Certain discovery devices, like depositions, are rare in arbitration. And so the parties can agree in advance to go to arbitration in order to reduce the cost. So although there's an upfront cost that's more expensive than filing a complaint in a court, at the end of the day, big picture, arbitration is usually less expensive because it could get you to the finish line faster and without having to go through as many procedures or hoops that you'd have to jump through in litigation.
And finally, what did you think of UFC 300?
Well, I was very happy with the BMF award, or the BMF title.
Max Holloway's fight?
Yeah, Max Holloway's fight, and just the courage that he showed when he was clearly winning, giving a very dangerous and powerful fighter in Justin Gaethje an opportunity to knock him out. Just pointed to the floor and invited to just throw down. And so either party could have won, and Max Holloway landed a very dramatic and historic blow that had face-planted poor Justin Gaethje and might have retired him.
Yeah, it was amazing.
Definitely brain damage involved.